If you guys have any doubts, you can let me know. Otherwise, we'll directly start with the units. There are 3 units that we're supposed to do today. We'll do unit 5, unit 6, and unit 7. All right, then I'll directly start. We'll be starting with accountability and control. This is one unit which is more oriented towards paper 2. So you'd see more of paper 2. We try to bring in paper 1 as well. And we'll be laying it down with examples as well. Okay, so the first question is, the judiciary is playing a more positive role in policy formulation, not just in limiting government actions, but also in mandating them. So basically talking about judiciary, how judiciary is, what role judiciary has in policy formulation. And we are saying that it's not just limiting the government action in the sense that it is only making policies so as to limit anything which is being negatively done by the executive, but also it has gone down to mandate the policies as such in terms of policy formulation. All right, so we'll have a look at the first question. This is a pretty simple one. Approach would be the same: intro, body, and conclusion. We'll see what we can do for introduction for the judiciary. We can always keep a standard introduction wherein we're trying to tell as to what is the main essence of judiciary. Second, in the main body, we'll talk about how judiciary is playing a role in the policy formulation, how it is limiting the government actions, and how it is mandating, and we'll try to conclude. Okay. The introduction, you can do it in two ways. You can talk about the Dicey's concept of rule of law, which is the Dicey's first principle of rule of law, wherein you have to restrict the arbitrary use of power by the legislative as well as the executive. Right. So this is the indirect relation to what the question is asking, limiting government actions. So you can bring in Dicey. Judiciary plays a proactive role in policy spheres to empower citizen rights, to limit arbitrary administrative acts, and to direct the executive in mandating them. Or you can directly talk about the judiciary and its various articles. Judiciary plays a proactive role in policy spheres, getting powers from Article 32 and 226 in terms of its judicial review for the Supreme Court and the High Court respectively. Article 142, under which the Supreme Court is ideally constitutionally enlightened to go around doing a lot of things in the mandate to ensure complete justice. And finally, Article 131, which talks about the original jurisdiction of the Supreme Court. Hitting on the main body, this was the introduction. We can standardize it for any judiciary question as well. Main body, judiciary playing positive role in policy formulation. Here, in this question, you only have to go down with examples. Try to think as many as you can. For instance, as far as the environment is concerned, you have Menka Gandhi judgment, you have the MC Mehta case. He's one of the most important pioneers as far as the environmental cases are concerned. Second, expanding the scope of fundamental rights through Putta Swami judgment, right to privacy, etc. You have to just mention the keywords and move on, because you have a lot of content to cover in this question and it is only a 10 marker, right? As far as social justice is concerned, you can talk about reservations, you can talk about Indira Sahni judgments, etc. Gender equality, you can talk about commission for women, commissioning for the women in Amini Navteej Singh George case, wherein you talk about the transgender rights, right? Sabrimala verdict, as far as the entry of women in temples is concerned. You can talk about Ram Prasad case as well, wherein reservation was extended, was said to not only be on the basis of the caste system. So these are some examples of it. You can say the judiciary plays a positive role in policy formulation. This is how they've also formulated policies. We'll now talk about how they've limited the government actions. You can also mention as to under what powers of articles do they enjoy that they're limiting. So judicial review is the first article, that is Article 13. Second, you have 32 and 226, wherein the Supreme Court and the High Court are empowered to do so. For instance, you have limited the authority or powers of the parliament. For instance, the Keshavananda Bharti case, which came out with the basic structure doctrine back in 1973. Right. Secondly, you would have seen that Supreme Court suo moto took the Manipur issue and directed the government to do something, wherein it also limited the government actions. Third is the minimum wage case. You can also talk about all the cases surrounding the Keshavananda Bharti case, right? Pre and post. You can talk about Esa Bomai case, wherein it has laid down the role of governor and the powers and principles that it has in terms of limiting the actions of the government. Mohit Mineral case, wherein decisions of GST Council are not binding on states. NJAC, this is one of the most famous examples that you can talk about limiting the government actions. Thirdly, we'll move on to mandating them, which was the other demand of the question. What do you mean by mandating? We are saying that intervention when necessary or judicial decisions are binding and non-compliance may lead to contempt of court also. That is why they become mandated. Okay. For example, you have Prakash Singh judgment, wherein you came out with police reforms. You can also talk about MC Mehta case, where it also mandated certain things. For example, CNG buses were mandated, etc. You have right to education as fundamental right through the Unni Krishnan versus Andhra Pradesh case. Shreya Singhal case struck down Section 66 of IT Act. This is again mandating in terms of what policy should be followed. Common Cause versus Union of India. You can also talk about the women guidelines that were set up. So this is again a mandating case, right? Again, because this is a 10 markers, you have to filter down the content as per the requirement of your handwriting and the space that you take. As far as the comment is concerned, you can also write that sometimes. Okay, so you need to understand this is something that everyone will write. What extra would you bring out in this question? You, because the question is on lines of judicial uh, intervention turning down to a judicial overreach, right? This can also be a possibility. So try mentioning that. This is something that will get you 1 mark extra because this is something that will stand out in your answer, right? So in that manner, you can also talk about something extra, which is write down that sometimes too much judicial intervention can obstruct the balance of power, also separation of powers, which is also a mandate of the rule of law, judicial interference, unelected nature of it. So to basically write down the negatives of judicial overreach, right? And because it's a 10 markers, you just have to write it down in 1.1 line, try to include all of it. Hence, judicial restraint is also necessary in democratic governance. Please make use of these two keywords. This is very important. Judicial restraint should be exercised so as to ensure democratic governance. Hence, the proactive role of judiciary can enhance ease of justice with a prominent role in policy formulation, promoting rule of law, constitutional governance. Try to include 2-3 keywords: rule of law, constitutional governance, and link it with the question. But keep it positive because you have already talked about something negative previously, right? So while we conclude, you have to end it on a positive note. Okay. Can we move on to the next question? If this is done, I think this is pretty easy.
Yes, sir.
Yes, thank you. The question is on citizen charter. Again, so all of this unit would be very easy, but we'll just quickly go through. Citizen charters focuses on empowering citizens concerning public service delivery. So we'll talk about two things: empowerment and public service delivery. And if you analyze it, it's only a 10 marker again. Approach will be the same: introduction, body, conclusion. We'll talk about a standard citizen charter introduction. We'll talk about a standard good governance conclusion, right? And main body explaining the statement. We'll also try to, so this is something that everyone will do. This is something that you have to do extra because it is because whenever we study the standard content, we do find some criticisms around surrounding citizen charter, and we'll also come out with some solutions to anti those criticisms that we put forward. And we'll, in explaining the statement, we'll talk about how citizen charter is empowering as well as ensuring public service delivery. Okay. Basic introduction of citizen charter is a voluntary public pledge by a service provider to uphold quality, transparency, accountability. You can try to mention the 6 principles of citizen charter movement in a small diagram if you wish to do so. छोटा सा एक diagram बना देंगे. Quality, choice, standard, value, accountability, and transparency. Coming down directly to the main body, Citizen Charter focuses on empowering citizens concerning public service delivery. You make a direct heading and you let us know the pointers through which we are empowering as well as ensuring public service delivery in terms of empowerment. So we'll talk about enhancing transparency and accountability. The charter creates moral obligations on the administration to serve the people, although the charter is not legally binding. This is one criticism that we'll try to bring about in the negatives. Empowering citizen, we have to talk about empowerment. How is it empowering? Because of the participation in the governance process. Whenever you talk about participation, you can mention in keywords such as collaborative governance, new public service, etc. Educate citizens about their rights and obligation and expected benchmark about public service delivery, proper grievance redressal, access of information to citizens about public service delivery, enshrines trust between the service provider and its citizens. So decreases the distrust, right, between government and citizens. Bottom-up approach or network governance approach makes it actionable accountability. Because we can see the process of social auditing furthering the process of citizen charter as well as people of involvement. The moral responsibility could be seen to be transforming into legal accountability, right? It shows the value of taxpayers' money. It shows deliberative democracy rather than just ballot box democracy. These are the keywords that you have to use, right? This can also be read in the context of policy. So deliberative democracy rather than ballot box democracy.
Sir,
Yes.
sir, please explain this point that moral accountability changes to legal accountability.
Moral response. Okay. So I hope you know what accountability means. So accountability is legal in sense. Okay. मतलब अगर if you're accountable for someone because it is legally bad, so you have to do it. मतलब it is on paper that if you do not do it, then your job goes. Unfortunately, in India, we do not have legal accountability in terms of actions of the bureaucracy, right? We are only morally responsible in India, in the sense that just because we are in the positions of power and that just because we are bureaucracy, we are expected to perform the developmental and welfare functions. However, what the citizen-centric governance does is that as and when citizens are involved, you see the moral responsibility. मतलब आप जो legally accountable लीगल नहीं थे बट आप morally थे क्योंकि आप उस पोजीशन में थे. We are now seeing it transfer into legal accountability in the sense कि अगर आपने ये नहीं करा तो आप uh, you can be prosecuted for it. समझ आया?
Okay, sir.
ठीक है. मतलब are you sure that समझ में आया? Otherwise I'll have to give out some more examples.
Sir, समझ तो आ गया.
ठीक है. Thank you. Yes. So now, as the keyword here is analyze, we also have to write some critical aspects and way forward. Again, because this is a 10 marker, 2, 3, 3, 4 points is enough in each. Okay. Critical aspect, various studies in India conducted by DAR, PG, PAC, Bangalore, etc. Okay. So you can try to disinclude it and directly hit it because it's a 10 marker. So you can tell us that it is not a citizen charter, but a manager's charter. There's a lack of citizen involvement, ignorance of the philosophy and goal of the charter, lack of updation, local language, vernacular language problems, not legally binding. You can also put up a quote of second ARC where it says that it is only a pious statement with noble intentions but having no practical significance. Okay. Hence, second ARC suggested the following: setting standards for each service and develop capabilities to achieve it, monitor performance, evaluate the impact, and local language and participation. You can try to mention some international case studies as well surrounding citizen charter, such as Singapore's Service Class Initiative, UK Service Standards, Australia's Service Charter of Victims of Crime, Passport Saver Project in India, which includes a comprehensive citizen charter. Only one or two of them, so one from India and one from international, can try to include because it's a paper one question. If you have an international case study, it is better. Conclusion: citizen charter steps to empower the citizens concerning public service delivery through above mentioned steps to be taken for quality public service delivery mechanisms. Also in a citizen charter question, it is always better to conclude it with moving from citizen charter to precariat charters. Precariat charters are nothing but more nuanced form of citizen charter wherein the grassroots level is enhanced. So, for example, you have to do a tribal displacement, this thing. So you also consult tribal. So it's a more bottom ground approach. Okay. Can we move on to the next question?
Sir,
Hanji.
sir, since we don't have legal backing for citizen charter, so how does this moral change into legal accountability?
Through tools such as social accountability, local self-governance. The more citizen-centric participation and citizen-centric tools of governance we go towards, the more we move towards transforming from moral responsibility to legal accountability. ठीक है, मतलब वो अचीव नहीं हुआ है बट हम अचीव करने की कोशिश कर रहे हैं. And how are we achieving? Through such tools.
Okay, sir. Okay. Thank you, sir.
ठीक है, you know the third question. The third question is on RTI. The backlash against RTI by the state hampered the citizens' right to know. Examine and point out the need to amend the RTI Act to provide protection to RTI activists. This is primarily a question on whistleblowers protection. Okay. We'll read this again. The backlash against RTI by the state hampered the citizens' right to know. Obviously, examine and point out the need to amend the RTI Act to provide protection to RTI activists. Now, because it's a 15 marker, we won't have enough questions on whistleblowers. So first 2-3 points can be on whistleblowers and rest can be on general amendment to the RTI Act in terms of whatever its negatives are. Okay. Again, standard introduction, body, conclusion format. In the body, we'll try to explain what this statement is a little, and then we'll move on to need to amend the RTI Act to provide protection. Okay. Second RC has described the RTI as march from darkness of secrecy to dawn of transparency. This is a direct quote from second RC that you can pick up for RTI. March from darkness of secrecy to dawn of transparency. The RTI Act has been instrumental in upholding transparency and accountability in the governance process. Wherever you have such accountability and control question unit ke, so for example, RTI or citizen charter, try to include the good governance keywords, transparency, accountability, etc. In the main body, we'll talk about the basics of the RTI and the recognition for the need of transparency. RTI has become the most potent tool followed in different parts of the world. Swedish Freedom of Information Law passed in the year. All of this is because it's either a 15 or a 20 marker. In a 10 marker, you can choose to ignore this, right? Indian Parliament enacted the Right to Information Act in 2005. It is a path-breaking legislation empowering people and promoting transparency. Now you're directly hitting upon the demand of the question. The backlash against RTI by the state hampered the citizens' right to know. RTI has enriched the fundamental right, Article 19, Subclause 1, about right to know about government activities, but backlash has hampered it, such as. So, what are the backlashes by the government in terms of RTI? So, recent amendment in the RTI by the central government, wherein we have probably lowered the freedom that these guys enjoyed. So we have hit upon the tenure, we hit upon the salary, we've hit upon the appointment, and said that all of this will now be done by the central government itself, right? Recent use of Section 22, Section 24, and Section 8, Subclause 2, wherein we are saying that the central government is denying to provide information under the arms of this sections, right? So information related to national security or information related to intelligence will not be disclosed under RTI, and they try to include all such information which you don't want to hide under the realm of national security and information. Third, RTI has overriding powers to Official Secrets Act and Indian Evidence Act. For example, Rafael case, and second, ARC has recommended to repeal the Official Secrets Act as well. We all read it in standard content. OSN 1923 has been asked to repeal so that we can also try to include all such information which the government has been hiding under the realms of Official Secret Act to include into RTI. Fourth, the loader panel recommended bringing the BCCI also under the purview of the RTI Act, but no action was taken on it by the government. This is another sort of backlash by the government in terms of RTI. Frequent delay in filing cases. Public information officer hasn't been appointed in all public agencies, and PIO lacks ownership of information. Second, ARC has recommended single window system and conversion of different information in one place for better efficiency. So we've tried to give you the problems as well as the solutions in the bracket. Budgetary problem and lack of funds disbursement from the government side. So government always has funds, functionaries, and functions. In terms of functions, although the act has been laid down, but we are not fully abiding by them in terms of official secrets, etc. Functionaries, we do not have enough PIOs, they have not been appointed, etc. Funds, we are not giving out enough money. So we can make 3 points out of these three. Rejection rate of RPI appeals have increased to 20% from 13% as per the Ministry of Home, in the Ministry of Home Affairs. So 13% pehle hota tha, 20% ho raha. This is again a governmental action in terms of backlash to the RTI. You try to write down all the negatives. Now you're talking about what is the need to amend the RTI Act and to provide protection to RTI activists. Although in the answer we have tried to keep it solely to provide protection. However, if you do not have enough points, you can also put down solutions for the above points in this particular part of the question. So in the recent past, nearly 100 RTI activists have been killed and nearly 200 RTI activists have been assaulted, which demands better legislative protection to the RTI activists. Hence, there's a need to amend the RTI Act to provide protection to RTI activists. Following provisions can be included in it, such as anonymity, keeping the details of the applicants very secretive or not to disclose it with anyone, whistleblower protection, legal and institutional support, public awareness and cooperation, use of IT, proper check and accountability. All of this gets a little repeated, so try to include certain solutions from above as well to complete the question in its entirety. Conclusion, hence RTI Act should be amended for ease of access to information and protection of RTI activists in the Indian context. The second ARC's recommendations of RTI can be implemented to address some of the structural challenges facing the RTI. Yes, any doubts of this question? Otherwise, move on to the next one quickly. We have a lot to cover today. That is why I'm keeping the pace a little up. If you have any doubts and want any repetition, you can let me know. Yes, can we move on to the next question?
Yes, sir.
Yes. The next question is interaction between the state and civil society has hitherto been largely neglected, especially in developing countries. Examine. It is only basically talking about how civil society has not been given due significance or importance in the present society up until now. That is it. So primarily in developing countries. Approach, obviously introduction, body, conclusion. In the introduction, we'll talk about the basics of civil society organizations because the question is pertaining to civil society. We'll talk about the context of CSOs and state interaction, how it is supposed to interact. So this was the premise of the question. Then we'll say, why do we feel that it has been neglected in developing countries? Yes, do you want to say something?
No, sir.
Achha, okay. Yes. Then we'll talk about why it has been. So we'll try to justify as to why do we feel that the interaction has been neglected. We'll also try to because the question is talking especially in developing countries. We'll try to talk about how it has somewhat been included in the developed countries notion, however still lacking in developing countries. And because it's examined, so we'll try to include some positives. We can. I am of a personal school of thought wherein I do not usually follow the directive word. So you can try to talk because you already talked about the negatives as well. So you can now directly talk about the solutions to overcome those negatives. Okay. In the introduction, we'll try to talk about what civil societies are. Civil society is considered as inalienable part of democracy. Tocqueville says CSOs are buffer between the state and the people. This is directly very relatable to this question because we're talking about interaction between state and society, right? So you can quote this thinker and say that acts a buffer between state and the people. Contemporary governance paradigms recognizes CSOs as an important stakeholder in the governance process. You can also try to draw a diagram wherein traditionally we talked about how the role of state was much bigger than market and CSOs. However, today CSOs enjoy an equal space as market and state, right? In the main body, we'll start talking about CSOs and their how we feel that it's been neglected in developed countries or versus developing countries. The World Bank has adopted a definition of civil society that was developed by a number of leading research centers. The term civil society refers to a wide array of non-governmental and not-for-profit organizations that have a presence in public life, expressing the interests and values of the members or others based on ethical, cultural, political, scientific, religious, philanthropic conditions. It depends on the number of marks that the question has been asked for. It's only a 10 marker, so you can choose to ignore all of this. In the globalization context, development is not just confined to either. So this becomes important. You try to explain as to the difference in developed and developing and why CSOs are different today as well as they were in the past compared to the past. In the globalization context, development is not just confined to either state or market. Instead, these two actors are collaborating with each other to provide goods and services. With the reappearance of a vibrant civil society, this process has now become multiple actor centric or multi-actor paradigmatic, with CSOs, NGOs, CBOs, self-help groups, etc., reacting or acting as responsible stakeholders with the state and market in the process of governance and development. Now there is a concept of third-party governance with active engagement of civil society. So you try to include a couple of keywords where you have to shorten down a lot because it's only a 10 marker. We'll now directly hit upon the demand of the question, interaction between state and CSOs with reference to developed and developing countries. In developed countries, we know that there's a civic political culture. The political culture is enhanced. However, in developing countries, you have a parochial and subject-oriented political culture. You have the greater participation of CSOs. However, here state is still more dominant and can turn out to be Leviathan or exploitative. That is why you need civil society, and that is why we say that the interaction is still limited. What are the limitations or reasons for the lesser interaction between the state and the civil society in developing countries? You have parochial nature of society in developing countries. People generally don't like to participate in the government process. Second, you have a prismatic nature of society. You have unbalanced polity as per Riggs in developing countries. You have overdeveloped nature of the state as per Hamza RV, top down and centralized instead of bottom up and decentralized of the state, which largely neglects the role of CSO, right? So this overdeveloped nature of the state, which is top down and centralized, leads to another problem of not uh, giving due importance to the role of civil society organizations. You have restrictive public policy, you have hard regulatory measures. The control is hard. We have not moved from regulation to facilitation as of yet in developing countries, right? Administrative challenges such as corruption, etc. You have red tapeism, crony capitalism, corruption, nepotism, favoritism, abuse of rule of law, etc. Other contexts like historical, in terms of we have a colonial past, political, for example, some developing countries usually have political instability surrounding them, for example, our neighbors, etc. Ballot box democracy rather than deliberative democracy, there's no proper actionable or social audit accountability mechanisms. These were the reasons why we still say that civil society interaction with the state and civil society has been, the interaction between state and civil society has still been neglected. You can try to still talk about some positives of the civil society organization in developing countries. However, due to rise of globalization, new networking governance, the role of CSO has been recognized in developing countries such as India. Try to talk about positives in the case of India, right? 12th five-year plan specially mentioned to work with the CSO at group level. Central government has made portals like Darpan to facilitate cooperation with the state and CSO. For example, National Policy and Voluntary Organization 2007, Darpan portals, Bhagidari model, Niti Aayog, incorporating Pratham report in the national development agenda, etc. Some of the prominent examples of synergy between government and civil society. Try to bring up, just learn 1 to 2 examples and replicate them in your answer. Conclusion. Julius Nyerere, this is another thinker, says people cannot be developed. This is not probably a scholar. People cannot be developed, they should develop themselves, right? Governments should work towards engaging CSOs in a meaningful manner in development by providing ease of doing voluntarism. Because when you talk about interaction, you need voluntariness in terms of their participation. That is why you have to provide the ease of doing voluntarism so that people can develop themselves via CSOs. Yes. Any doubts with this question? Can you move on to the next one?
Yes, sir.
Okay. Next question is on social auditing. Social auditing is not just saving the money, it creates positive impact on governance. Social audit, you have to talk about how it is in terms of, majorly in terms of economics, in terms of your saving of resources. However, not only just this, but it has a larger goal, which is a positive impact on governance overall. We have to comment. This is a very simple question. You have intro, body, conclusion format. In the body, we'll talk about something about social audit, and then we'll have to try to justify the statement, same giving 2-3 points on how it saves money, and then a lot of other points on how it creates the positive impact on governance. And we can also, because you have to comment and it's a 15 marker, try to bring out some limitations surrounding social audit, negatives, and then how do we correct them into positives. That is the solutions or way forward, and then we conclude. Introduction of social audit is a way of measuring, understanding, reporting, and ultimately improving an organization's social and ethical performance. It is a technique to understand, measure, verify, report on to, and improve the social performance of the organization. Always prefer why. So when you talk about state becoming Leviathan and markets being capitalist in nature, you need social audit mechanisms, all of this. So the background context of social audit would also be used in the introduction. You can also try to include give the evolution of social audits in brief. 1994, you have the Madhun Kishar this thing, and then there's Jan Sunwai, 2005 Maganrega. You have Gram Sabha Andhra model of SSAT. Meghalaya was given statutory recognition in terms of social audit in 2018. So, Navdeep, we were talking about legal accountability, right? So, in Meghalaya, that legal accountability is now there because of the statutory recognition given to social audit mechanisms. Social audit is not just saving the money. Aim is not quantitative, rather qualitative. So not just saving money में ना एक आध example money पे भी देना पड़ेगा, that the ultimate aim is efficiency of resources and whether or not the resources have been effectively utilized. Then you say that it is not just about saving the money. Why? Because it's not only quantitative but also qualitative. It is not output oriented rather than outcome oriented, right? So it is focusing on outcome as well. So it's not just saving the money. Saving the money would be output orientation, quantity. It's also qualitative. It's also outcome oriented. That is why it is different from statutory audits. Evaluates the performance of the program on ground with the help of CSOs. Thus, it increases the scope of efficiency and transparency. For example, Bihar Panchayati Raj Institution Strengthening Project, in which they introduced social audit to examine financial transactions, which resulted in the proper utilization of funds. Then we'll directly hit on the second part, which is the positive impact on the governance. How is it creating a positive impact on governance? Try to include as many keywords on good governance that you can. So you have a bottoms-up approach. It makes the governance outcome oriented instead of output oriented. You ensure transparency, efficiency, effectiveness, accountability, and also equity. Improves the institutional performance. It makes governance democratic and collaborative. Talk about NPS, NPG. It makes governance citizen-centric and agile. It enhances the scope of grievance redressal, which makes governance more responsive. You also strengthen democratic process in general. You can also try to include other keywords if you wish to, and come out with some examples now. For example, Maganrega, social audit increases effectiveness. SSAT, Andhra Pradesh successful model. Karnataka Rural Water Supply and Sanitation Project, Bhumi Keen Kisan, Landless Farmers Social Audit in Telangana. Also, I did not know all of these. I had to pick it up just to provide you with model answers so that each one of us can pick up 1 to 2 and then learn them, right? Nirmal Gram Puraskar in Himachal Pradesh, improved sanitation hygiene in the village through social audit. Now we have to also talk about some negatives and then some solutions for it. Low participation, low awareness, non-enforceability, lack of actionable accountability, which is again non-enforceability. Only two schemes covered mainly, which are midday meal scheme and Maganrega. Other schemes not properly implemented. Gram Sabha lacks resources to implement such activities. Awareness is already talked about. It's low political culture also, right? So all of these are some limitations. Way forward, statutory recognition is the need of the hour. You have to sync them with CAG reports. You have to aware them through CSOs. You have to turn the moral responsibility into legal accountability. You need to have local participation, especially women empowerment through SHGs. Gradually, more schemes should be brought under the social audits. This would be the way forward. You can try to include a couple of diagrams if you wish to. These have been directly picked up from the notes. These are some examples. You have the need for social audit, citizen need primarily citizen empowerment and government accountability, output to outcome, consensus orientation, concurrent audit, collective decision making, transparency, etc., etc. You can also try to draw a social audit cycle if it's a 20-marker question, right? Where you define values and objectives, identify key performance indicators, collect qualitative and quantitative data, evaluate data, which is both internal and external nature, and publish social audit results. Right, fine with this question. Can we move on to the last one for this unit, and then we'll quickly switch to the other unit.
Yes, sir.
Perfect. All right. So in theory, the CSOs or the civil society organizations promote cooperation between people and public, but in practice, their activities restrict the promotion of government programs. Almost a similar question in terms of interaction between public and the civil society. However, here we're saying that we have to it acts as a bridge between the public and the public government as well as the people in general. However, in practice, that is in reality, their activities, that is the CSO's activities or parastatal body activities in general, restrict the promotion of government programs. You have to analyze it, try to give down some examples. Also, because it's a negatively connotated question and we are talking about governance, you have to end it positively. So we'll say no. We'll also try to disagree with the statement in the sense that although this can be seen to be so, but however, it is still necessary and this can be done to improve the current status. Okay.
Sorry.
Right. So intro, body, conclusion. Yes.
Sir, what include parastatal bodies?
Yeah, so all these bodies such as civil society organization, community-based organizations, SHGs, NGOs, all of these are known as parastatal bodies. It's usually a negatively connotated term. तो जो question की essence है ना कि वो it restricts the promotion, तो उस case में हम उनको parastatal bodies बोल देते हैं. ठीक है? ये जितनी भी bodies हैं आपको बताएंगे, CSOs, CBOs, NGOs, SHGs, all of these.
Sir, can government bodies be included in this?
Sorry?
Can government bodies be included in this?
No, they cannot be. We are saying that they are acting as parasites on these bodies, which is the government bodies. Okay.
Okay, sir.
Right. So intro, main body, conclusion, two parts. First, explain the cooperation between both and then their limitations in context to the question. Introduction, civil society organizations foster collaboration with citizens and public services, enhancing community engagement, promoting shared societal well-being. Contemporary governance, again, cut copy from the previous question. Now hitting down directly to the main body. CSO promotes cooperation between people and public service organizations. How? Advocacy for vulnerable people and their rights, for example, NAS Foundation and LGBTQ rights. Shaping public policy, for example, Oxfam reports and instruments and policy. Third, community engagement or social capital and public participation. For example, there's an NGO called Goonj, which is talking about rural development and disaster relief. Transparency and accountability as civil society, for example, MKSS and RTI. Agitator on behalf of aggrieved citizens, for example, Common Cause, which is an NGO fought for electoral reforms and fundamental rights. Sixth, shaping public opinion. Again, so public policy, we have given a separate example. Public opinion, we can give a PRS legislative research, which is acting as a non-governmental organization, right? Second part, their activities restrict the promotion of programs. How does it do so? They work for their, so we have to basically talk about the negatives of CSOs that we have read in our basic content. Okay. So they work for their own vested interest sometimes. Intelligent Bureau report says that NGOs have been used for Western vested interests. There's a Western bias attached. For example, you might have heard the Greenpeace controversies. For example, recent actions on Ford Foundation and Greenspan International. Third, shaping negative public opinion about the government programs can hamper its implementation. That is why you start calling them as parastatal. Media influenced by CSO and its negative impact on government programs, etc. So this is how they have been seen to restrict the promotion of government programs. You can also talk about the Western funding that is coming in. Uh, they can also be used as channels as channels to channelize black money. Right, all such negative things relating to them will always lead to the restriction of government programs. Because you've talked about the negatives, but it's a positively connotated concept of CSOs in general. We'll try to conclude it with a way forward of how to improve it, and then a good conclusion. Cooperation and not confrontation, better than positive regulations on CSOs. For example, Foreign Contribution Regulation Act has been properly implemented. Proper accountability and transparency needs to be put in place, not only for the CSOs, but as well as for the government, so that there's mutual trust between the two. Conclusion, hence, for inclusive, democratic, sustainable, and participative governance, the interaction with the state and CSO is very crucial and needs to be improved. That's it. Right. With this, we come to an end to this unit. If you have any doubts, this is a pretty easy unit. You just have to have some examples and just learn some keywords, and then I think that'll be good to go. Any doubts with this? Otherwise, move on to the next unit directly. All right, seeing none, I'll move on to the next unit directly. We only have 4 questions from this unit. It's an administrative law unit. You all usually see one question every year. There can be a chance that you could probably see a couple of questions in some odd years, but that has usually been not the case unless 2022. So yes, it's an important unit in the sense that you usually get one question at least from this unit. Also a very small unit in a sense, but in which ways we'll try to cover it in its entirety. Subordinate legislation has its drawbacks. This does not negate the fact that it is also quite beneficial. Examine. This is a very standard question that has been asked in 2023. We always read about the positives as well as the negatives of subordinate legislation. This is exactly that although subordinate legislation is somewhat negative, but it is also quite beneficial. We'll talk about both positives as well as negatives, and we'll try to talk about how to counter these positives and negatives to make it useful. So we'll also talk about the solutions we always read about subordinate legislation. Very direct question. Directly moving on to the answer. The approach would be obviously the introduction, body, conclusion format. Introduction about delegated legislation or subordinate legislation. Yes, so you read it as delegated legislation in your contract. This is also, we also call it as a necessary evil. Right, this has also been a previous question that delegated legislation is a necessary evil. So you talk about why it is necessary, why it is evil, and what we can do to counter to achieve a balance between the both and make it positive. You talk about disadvantages, you talk about disadvantages, can also write drawbacks first and then advantages. You can follow either of the approach, and then you have to examine it in the sense that what can we do, and you have to conclude it. Okay. Introduction. According to Sir John Salmond, subordinate legislation is that which proceeds from any authority other than the sovereign power. Delegated or subordinate legislation is about lawmaking by the executive on the basis of power delegated by the legislation. For instance, the drug and cosmetic rules, all sort of rules, bylaws, ordinances, etc., are sort of delegated legislation. SEBI guidelines, income tax rules, rules in the Companies Act, etc. Directly hitting on to the advantages, the legislative, due to the paucity of time, passes law in skeleton format and the flesh is added by the executive. This is a good keyword that you can always take in, that because legislature has a lot of other things to do as well. So a skeleton framework is provided by the legislature. However, the flesh is left to be added by the executive in terms of delegated legislation. So this reduces the burden on the parliament. Second, it promotes flexibility and swiftness in lawmaking. For example, you had COVID-19 regulations directly by the executive. Third, the executive has implementation experience and hence it can add adequate details in the law based on expertise. So expertise role comes into play. Intricate details of administration can only be known to the administrators, which is the bureaucracy. So when you delegate it down, they are better people to add it. For example, the Medical Council of India guidelines. Fourth, responsive in nature. Delegated legislation allows swift responses to emergencies or unforeseen situations, addressing issues promptly without waiting for the next legislative session. For example, health emergency regulations also seen during COVID-19. This is because you need a lot of time to get things discussed and passed in the legislature. Also, there is a possibility that the legislature is not always available. Sometimes it's not in session. That is why uh, it becomes more responsive in terms of exigencies and emergencies. Fifth, it includes in technical and specific details into laws which might be cumbersome to include into the primary legislation. For example, rules under the Companies Act. It provides opportunities for people for participation through delegate legislation. For example, you had environmental impact assessment. You also had EIA guidelines on public opinion, right? So all of this can only be taken into play if the legislature has given it down for delegation. Seventh, you have a lot of scope of experimentation. You know that Magan social audit was laid down on the experimentation basis by the bureaucracy, that is, in terms of delegated legislation, right? And once it was a success, it was implemented nationwide. So authorities can experiment with different approaches and regulations to address issues without need for complete overhaul of time legislation. For example, GST rates. However, now we'll move on to the second part of the question. It has some drawbacks such as affects the separation of power. That's very obvious that lawmaking is the primary activity of the legislation as per theory. However, giving it down to a delegating it down to somebody else is would always contravene with the balance of powers and affect the separation of powers concept. Executive can act arbitrarily by adding clauses, subclauses, and rules which are not as per the mandate of laws. For example, criticism of land acquisition laws, right? So arbitrary addition of certain clauses, etc., to make them in their own favor. Instead of flexibility, it had also brought about a jungle of legal system and chaos. Jungle. So as you can see in a prismatic society, right? There's a lot of chaos and no clarity in terms of legality, etc., because of a lot of overlapping and cross-purpose laws, because it was not made by the legislature. It may become a victim of the ivory tower approach of the bureaucracy. The administration engaged in delegation is small in size, and there are fewer individuals, so they may be influenced easily by powerful and strong people. Sixth, legislation is a large body, so it's difficult to influence the decision making by the legislature. This is basically a confirmation of this point. We can try to come up with some facts. A study has shown that from 2008 to 2012, only 101 pieces of delegated legislation, or a total of 6985, had been scrutinized by the committee. Right. So this is again a negative, wherein we say that although delegated legislation is supposed to be scrutinized finally by the legislature, yet it is only 100 out of approximately 7,000 delegated legislation that have been scrutinized by the legislative committees. We have to also examine. So, although delegated legislation like administrative law is considered a necessary evil, hence there are safeguards also created, such as committees of subordinate legislation, judicial intervention, social accountability mechanisms such as RTI and civil society, public opinions, etc. Way forward, again, the Committee on Subordinate Legislation has made the following recommendations in order to streamline the process of delegated legislation in India. The power of judicial review should not be taken away. A financial levy or tax should not be imposed by the rules. So the power of purse should only lie with the legislature. Language of the rule should be simple and clear. Legislative policy must be formulated by the legislature and laid down in the statute, and the power to supply details may be left to the executive. So they should be more defined in terms of what the executive can do once they frame that particular law by the legislature. Subdelegation in very wide language is improper, and some safeguards must be provided before a delegate is allowed to subdelegate his authority. So the parliament is delegated it to the topmost IAS officer. Now they have been subdelegating it. This again becomes very tedious, and this becomes also very negative in the sense that they trust the legislature, which enjoys the trust of the people, has been delegated to somebody else, and now that trust is again been delegated to somebody else, right? So subdelegation is another problem. Discriminatory rule should not be framed. Rule should not travel beyond the rule-making power conferred by the Parent Act. So, for example, whatever the power legislature enjoys, if you even stream bypass that, then that's a problem, right? This is exactly what this point says. There should not be an inordinate delay in making rules by the administration. The final authority for the interpretation rule should not be with the administration. The final authority for the interpretation should lie with the legislature. Exactly. Or if you have to interpret it only once it's done, judiciary, right? Not the executive. Sufficient publicity must be given to the statutory rules and orders. Conclusion, delegated legislation like the administrative law enables the public administration to meet the challenges of governance and meets the needs and aspirations of the citizenry by being responsive. But it is also imperative that legislative control. So there are two kinds of control that we read over in delegated legislation solutions. One is judicial and the other is legislative. So both of them is the need of the hour. Hence, delegated legislation is necessary, but there must be safeguard without which it is termed as new despotism by Lord Hayward. You have heard about new despotism?
Sir.
Yes. Yes, Navdeep.
Yes, sir.
All right. So we'll move on to the next question now. Otherwise, if you have any doubts, then let me know.
We can move, sir.
All right. The next question is, all tribunals are courts, but not all courts are tribunals. Explain. We'll try to explain it in two sense that all tribunals, how are they court, but how are all courts not tribunals? That's it. It's a 10 marker. There's nothing more that we can do. Also, we'll try to take down some examples of tribunals and courts. Introduction, explaining the thesis statement, conclusion, try to link it to the administrative law, because I told you in the orientation session as well, or the answer writing session that I took, that you have to zero it down as to which question belongs to which part of the paper and therefore which unit. Had this question been a standalone, we'd have seen it question to be a paper two question. However, because this question came in paper one section A, we could zero it down that it belongs to administrative law. So please try to somehow link it to administrative law as well. Tribunals are considered as courts, which are quasi-judicial bodies known for its swiftness, efficiency, and expertise. Main body, all tribunals are courts because tribunals, just like traditional courts, involve legal proceedings, including the presentation of evidence, examination of witnesses, and legal arguments. Second, decisions and orders issued by tribunals are legally binding and enforceable, as has been in any ordinary court. Judicial members are also taking part in the proceedings as the presiding members, although there are executive members as well, but in ordinary courts, you have judicial I am so sorry. I did not realize that the internet has been disconnected. Am I audible now?
Yes, sir.
Yes. Can you tell me till where was I covering last?
Sir, this tribunal question.
No, this obviously, did I complete it till the end?
No, sir, we were in half. Second part.
Second point.
Second part. This, sir.
Right.
But not all courts are tribunal.
Okay, so we'll
Yes.
now try to tell as to why not all courts are tribunals, in the sense that we'll try to differentiate between courts and tribunals. So tribunals are made for the specialized function, whereas courts are for general purposes such as civil, criminal, family matters, etc. Courts consist of professional judges with legal expertise. However, tribunals also have administrators coming in. Third, you have a fixed procedure in terms of legality that the courts follow. However, tribunals have a little flexibility that they have to offer. Also, tribunals do not follow the traditional hierarchy based appointment, in the sense that you can also have retired bureaucrats coming in and in the tribunals. However, this is not the case with ordinary courts or traditional courts. Moreover, retired justices from the ordinary courts can also come into the tribunals, which is not the case of the traditional courts. You know that appeals from the traditional courts go to the higher courts directly. However, as far as tribunals are concerned, you can also have appellate bodies within the tribunals or for the tribunals, or they can directly go to the judiciary. Because it's a paper one question, you also try to link it with the administrative law aspect, and you can talk about joint administration in this case. To conclude, try to include certain keywords for the purpose of which courts are established in the first place and conclude in them. So, for example, for effective governance, accountability, transparency, justice, and grievance redressal. Right? This is about this question. Can you move on to the next one?
Sir, how to link this with administrative law?
Yeah, so if you have a look at it, we are basically saying that you can link it to the Droit administrative process, where in France you still have a dual code system. This is the Droit administrative. Okay, you have dual codes, wherein you have traditional codes as well as specialized codes.
Yes, sir.
Yeah. All right, we'll move to the next question. The next question is the administrative state is the creation of a power to bind us with rules, etc., that are not made by the legislature. Discuss the constitutionality of the administrative state and its future. It's a 20 marker question. It's also very important. There's something new that whatever you've read in terms of the administrative state, this is also you can link it to that it is an administrative law question. So we are saying that these are the rules. The administration is the power that is being enjoyed because of the rules and regulations that it lays down, which is not made by the legislature. Is this constitutional enough or not, and what is the future of such an administrative state? That is primarily the questions you have to analyze in its entirety. We'll see how we'll go about this question. Introduction will try to explain about the administrative state in brief. In the body, we'll try to link about what administrative state is and what it contributes or decontributes towards the separation of powers. We'll also try to talk about the constitutionality of administrative state, and we'll try to talk about the future of way forward, which has been asked in the question. We'll finally then therefore after move towards the conclusion. So 20 markers, so we'll keep it a little explanative, right? Introduction: the administrative state refers to the complex system of executive agencies, departments, and bureaus that are responsible for carrying out various governmental functions. These agencies have the power to create and enforce regulations, rules, laws, bylaws, ordinances, etc., that have the force of law, even though they are not created by the elected representatives in the legislature, because of the concept of delegated legislation. This has raised questions about the constitutionality of the administrative state and its future, and then we directly hit to the question. We are giving a brief background in the sense that the state has undergone tremendous changes since 1950s. The post-World War II gave rise to a welfare state, which came to be characterized as an administrative state by Dwight Waldo. This state adopted a constitutional system of democracy and accountability, wherein all the institutions of state were made accountable to the legislature. Not only the executive, but also its agencies were made accountable to the legislature. Like, for instance, in India, it is CAG, UPSC, ECI, CVC, etc. All are some or the other way accountable to the legislature in its entirety. right? So here we talk about the essence of the question, that although these are not made by the legislature, but still the accountability holds true and legislature is supreme because of the concept of autochthony, as has been enshrined in the preamble of our constitution, that we the people, right? You try to include certain keywords so that you explain the essence of citizen centricity. And now you try to link about the administrative state and separation of powers. So one of the primary concerns about the administrative state is the separation of powers. The constitution grants the legislative branch the power to make laws, while the executive branch is responsible for enforcing them only, as per constitution. When administrative agencies create regulations that have the force of law, they may be seen as encroaching on the legislative function or the legislative domain. Critiques argue that this violates the principle of separation of powers and undermines or relegates democratic accountability, right? For example, social media regulations, same like executive environment pollution regulation, 5,000 rules made during COVID pandemic, etc., etc. You can talk about the rules and regulations that are under the realms of delegated legislation. Talking about the whether or not it's constitutional, so constitutionality, you talk about a little. Modern constitutional state is based on the principle of limited government, rule of law, and separation of power. Rules framed by the executive goes against the constitutionality of limited government and separation of power. Some critics argue that it has become too powerful and accountable, but the argues that it is necessary for effective governance in a complex and rapidly changing society. You give out both the perspectives. Also, instead of saying that, you can obviously say that they go against the constitutionality of limited government and separation of powers, but try to be a little diplomatic in the sense that when used arbitrarily according to the whims and fancies of the executive, right? Just try to, because you cannot directly go against the previously or already established or status quo of the system that is at hand. So try to include certain diplomatic sentences wherein you can not totally be wrong. So it goes against the constitutionality only when used arbitrarily and according to the whims and fancies of the executive in hand. What would be the future way forward? Greater democratization of participation, increasing transparency, judicial oversight, app checks and balances, committee on subordinated legislation, necessity to review the delegated legislation by the committees, etc., etc. Right? Conclusion: emergence of new types of problems and challenges such as right to privacy, data protection, cybersecurity has led to increased intervention of state in different spheres. However, the principle of constitutionalism should be given utmost importance while performing various actions, wherein it is the legislature which enjoys the confidence of the people, and because we the people, therefore, supremacy of people should be ensured, and majority of the work should be done by the legislature, or they should at least define as to what needs to be done by the to the people that they delegate to. Yes. Did we understand this?
Yes, sir.
All right, we'll move on to the next question now. The last question for this unit: judicial review, prevention of misuse or abuse of administrative power, and provision of suitable remedies are the basic principles of administrative law. Justify as how various organs of the state are able to uphold these principles. You have to talk about how judiciary is able to uphold the principles of administrative law. We have to talk about how administrators are able to uphold the principles, etc. Okay? Judicial review, prevention of misuse or abuse of administrative power, and provision of suitable remedies are the basic principles of administrative law. In the introduction, we'll talk about what is administrative law. That's the basic. In the main body, we'll explain the first first part of the question about basic principles of administrative law, which I mentioned. The basic principles in judicial review, prevention of misuse or abuse of administrative power, and the provision of suitable remedies. These three being the basic principles. And then we'll say how the various organs of the state are able to uphold these principles. The various organs being judiciary, legislative, and executive. And then we'll try to conclude. According to Ivor Jennings, administrative law is the law relating to the administration. It determines the organization, powers, duties of the administrative authorities. Basic principles of administrative law. Administrative law has four basic principles. It deals with the composition and the powers of the administrative authority. It fixes the limits of the powers of such authority. It prescribes the procedures to be followed by these authorities in exercising such powers, and it controls the administrative authorities through judicial and other means. These are the basic principles that you read in the standard content, right? Now link it to the pointers that has been asked in the question. The 3 pointers being judicial review, prevention of misuse or abuse of administrative power, and third, provision of suitable remedies. Judicial review, the principles allow the judiciary to review and invalidate administrative decisions if they exceed the authority granted to the agency or any rules made arbitrarily. It ensures administrative bodies function as per the constitutional mandate and within their boundaries. It serves as a check on the administrative process and functions. For example, striking down of Section 66A of the IT Act 2000. Prevention of misuse or abuse of administrative power, by setting clear rules and standards for administrative actions. The administrative law seeks to curb any misuse or abuse of power. For example, misuse of ED or CBI Section 124A. The main object of the study of administrative law is to unravel the way in which these administrative authorities could be kept within their limits. So the primary aspect of this administrative law should be to how to keep them in the limits so that discretionary powers may not be turned into arbitrary powers. So discretionary powers, we also read it in standard content. The discretion is already granted by the constitution in a lot of ways. However, we do not want this discretion to translate into arbitrary powers, right? Arbitrary usage of powers. For example, the RTI Act. Third, provision of suitable remedies. In cases where administrative actions are found to be unlawful or unfair, administrative law also provides mechanisms for affected parties to seek remedies. You also have grievance redressal mechanisms as a part of administrative law, right? This is the second part of it. So provision of suitable remedies is directly linked there. This could involve the correction of the administrative decision, compensation for damage, or other appropriate relief as may be decided. It also provides specific guidelines or proper grievances redressal mechanisms for suitable remedies. For example, the National Green Tribunal in India provides a platform for individuals to seek remedies in their environmental matters, right? These are the 3 pointers that you've covered according to the main demand of the question. It's a 15 marker, so you cover all the three separately. Now you have to tell us how various organs of the state are able to uphold all these three principles, right? Can also structure in other ways, writing first how all the three organs are trying to uphold these principles and then their weaknesses end, or you can directly talk pick up the 3 points. So legislative organ, judicial organ, and executive organ. Legislative organ is making a legislation with clear-cut guidelines, acts, laws, rules, can form committee, etc., making tribunals. What are the limitations of the legislative organs? That they talk about delegated legislation. Delegated legislation has its own flaws. There are flaws in acts. There's low sitting in parliament. There's low participation, etc. Judiciary, what are the means for judiciary? They judicially review, this have suo moto recognition of cases. They can also interpret rules. What is the negativity in judiciary? High pendency, rigid mechanism, lack of judicial restraint, hampering the separation of powers. Executive, while implementing the law, they must adhere to legal norms, internal checks and balance mechanism, executive rules and tribunals, delegated legislation, they play an important role in. Negatives, delegated legislation, if used arbitrarily, is negative. Using more discretionary and arbitrary powers, hampering the separation of powers, all of this. So legislature, judiciary, executive, how are they doing it and what are the negatives with it? Try to come up with a common way forward for all the three so that you can counter the negatives or the limitations of the three. Grievance redressal mechanisms, fixing accountability, making judiciary efficient, accountable, transparent, responsive. So will the legislature and executive, right? Conclusion, as the state's nature changes, the role, functions, and powers of public administrators also change, and hence the content of administrative law also changes because the state's powers and functions are changing. So administrative law is also changing. Hence, to uphold the basic principles of administrative law, there needs to have better cooperation and collaboration between various organs of the state with necessary to ensure necessary efficiency and effectiveness in each of the organs. Right, with this we come into this unit as well. Any doubts before we start moving to the next unit, which is CPA?
Sir.
Yes.
No, sir.
Okay. We'll now move to the last unit. It again has 6 questions, although almost similar. So we'll try to keep up the pace. If you have any doubts, you can let me know. Okay. The first question is, the Constitution of French Republic does not prohibit ministers from the leader of a political party. However, it is customary that ministers should not occupy such a post to ensure impartiality. This is basically saying that in France, it is a matter of custom that the minister is not supposed to occupy a position of leader in a political party. However, although it is not constitutionally forbidden, so it has become a custom. What does it do? It ensures impartiality and reduces your conflict of interest. Right? This is the main tone of the question. It's a 10 marker. So write down 5, 6 points on why or how this is useful and whether or not it should be followed in India. So in the context of India, you just come down that this is not constitutionally forbidden in India as well. However, it is only in the benefit that if we also customary allow it in customary make it a customary practice in India, we will ensure impartiality. Right? Approach, introduction, body, conclusion. Introduction, brief introduction about the French system of polity. Because you're talking about the French Republic, you can try to include it as a French system polity. In the body, try to explain the thesis statement in the sense that you just have to explain this to its entirety and then conclude. In the explanation, also try to analyze the reasons or the positives of this, right? Because in essence, this is a positive practice because you're also talking about ensuring impartiality via this practice. Introduction. France as a quasi-parliamentary or a semi-presidential form of polity. The French Republic is governed by the president, prime minister, and cabinet. The prime minister of the okay, so we know that president leads their foreign-related policies. That is why we all know the name of Macron, which is the prime minister. However, which is the president. However, we do not know who the prime minister is because he relates to the internal policies that are there in the country. So the prime minister there leads the policy related to the republic, while the president leads the foreign-related policies. That is why we have a semi-presidential form of polity in France. Body. In France, the constitution of the French Republic does not explicitly prohibit ministers from being the leader of a political party. However, it is a long-standing tradition, just another word for custom, so that you can make the examiner better understand, you know it, that ministers do not simultaneously hold the position of a party leader. This practice is rooted in the principles of impartiality and good governance and avoids conflict of interest. Okay, so you're including on. Okay, yes. So you are repeating it, but also trying to add a certain number of new keywords as impartiality, good governance, and simultaneously do not hold it, so that you can let the examiner know better that you have understood the question. Now you'll have to come out with a number of pointers on now why this practice is good. First one being conflict of interest. Holding both positions can lead to conflict of interest. For example, if a minister is also a party leader, they might prioritize their party's agenda over the broader national agenda, potentially undermining the principles of democracy and representation. Right. So this is where you can also talk about short-term political gains versus long-term national agenda, which has also been talked about by MP Foley, right? So in this case, conflict of interest arises between this, and if you're also a party member, you might return or resort to short-term political gains as well, which is negative in the long run. First, this. Second, you also try to talk about the conflict of interest example of Vijay Mallya, wherein he was also a member of the Civil Aviation Committee while being the chairman of the while being the chairman of the Kingfisher, right? So this again is a conflict of interest. You can try to bring out certain examples and linkages as these. Second, it goes against the ethos of separation of power. This practice, which is practiced in France, reinforces the separation of powers between the executive and the legislative. Ministers being separate from the party leadership helps prevent any undue influence in the legislative process. Third, obviously, because this is a keyword that has been mentioned in the question itself, so if you talk about it, impartiality. The primary reason for this practice is to ensure the impartiality of ministers in carrying out their official duties. When ministers also serve as political party leaders, there is a risk of their decisions and action being influenced by partisan politics, which is the opposite of impartiality, right? Rather than the best interests of the nation. This separation helps maintain the integrity of the government at hand. Try to talk about a bit in the Indian context. In India, ministers are also part of the political parties, which leads to various types of favoritism, corruption, nepotism, abuse of power, misuse of authority, going against the principles of rule of law and separation of power. Right? Try to write down it in a line because it's a 10 marker, and then also try to conclude it by saying that this tradition will, if applied in the Indian context, will also help to ensure that government officials prioritize the welfare of the nation over their petty party or partisan politics. Yes. Can we move on to the next question?
Yes, sir.
Right. Thank you. Next question is, the studies in CPA got momentum in 1980s and 1990s with a new objective and orientation than its previous counterparts. It's basically talking about how 1950 CPA was different from 1980s and 1990 CPA. You also have to critically examine, in the sense that you have to tell them that although we had a new objective and new orientation in the later part, which is 1980s and 1990s, yet the 1950s still laid a big foundation because the commonality still existed in the new objective and new orientation, right? That is why it is to cater to the critical examine part as well. It's a 20 marker. So try to talk about what was there in 1950s, call it as old CPA. Then try to talk about what is there in 1980s and 90s. Try to call it as new CPA. Distinguish between new CPA and old CPA in terms of their objective and orientation, and then tell us how still new CPA is derived from old CPA, and then conclude. This is what the primary format for this question might look like, right? Or structure. So, right. Introduction, brief about the old and new CPA. Body, old CPA, its failure and weaknesses. New CPA, new objective and orientation. Critically examine similarity and some weaknesses of new CPA. Yes. So old CPA, हम बताएंगे क्या है. Then we'll talk about its negative, so that we can talk about new CPA. In new CPA, we'll tell what are its new objective and orientation. And then because it's critically examined, we'll also try to talk about how new CPA is similar to old CPA and what are the negatives of new CPA as well, and what would be the solutions to make it better. Right? CPA is a cross-cultural, cross-national study of public administration with a comparative perspective. It arose in the 1950s and 1960s and attempted to conduct cross-cultural studies using an empirical, descriptive, ecological approach. Try to include as many keywords in the introduction as you can. We know that CPA is empirical, we know that CPA is descriptive, and we also know that this is the first theory which is an open systems theory than the previous ones which were closed systems. So you try to include the keyword as ecological as well, which was led by Fredericks. Try to include some other thinkers. Palombara, I think he was in Russia to compare the administrative system. Riggs, who was sent to Thailand, right? Brebanti, I think he was sent to, I'm not able to recall, but I think it's China, but we'll check. So yes, Palombara, Russia, Riggs, Brebanti, and others conducted research studies in various countries in an attempt to build theory. The CPA's primary goals are as follows. You know that the main function of CPA was twofold. First was to build a universal grand theory, right? We wanted to come out with a universal grand theory of public administration. And second was obviously comparing the characteristics of developed, developing countries, etc. So to construct a grand theory of public administration which had a universal applicability. And second, understanding the unique characteristics of developing countries in order to improve the policy and administrative reforms. This was the old CPA. Now we'll talk about the failure of old CPA. By 1970s, CPA started declining as they adopted lofty ideas of building universal theories and objectives which it could not achieve. The idea of universal grand theory could not be achieved, and this was in the context of old CPA. Therefore, we started with the re-emergence of CPA during the 1980s and 90s with new CPA paradigm, wherein we started to focus more on not so universal grand theories, but middle range theory building. Okay. What was the middle range theory building? That we're not trying to see the universality, but we're trying to compare the similar subsystems. So subnational पे भी तीन जैसे North India, North India, Central India, South India. So North India से जो matter करेगा same, हम उनके administrative systems को compare करेंगे. So this was the middle range theory building, comparison of the similars, right? So during the 1980s, the CPA began to emerge in the form of a new CPA led by Farrell Heady, OP Dwivedi, etc. What were the factors of re-emergence? Theoretical developments like public policy, PCA, NPM, all of this came in during the 1980s. So all of these theoretical developments, along with public policy, led to the re-emergence of CPA. You had globalization coming in the world by 1980s, which led to more comparative research and more availability of resources for comparative research. Several publication models. We moved to a multipolar world from a bipolar world, right? So bipolar to multipolar. That is why you had a re-emergence of CPA, because there was more interconnection. And with the coming in of globalization, you had started multilateral institutions. These multilateral institutions started supporting the CPA studies, as EU, ADB, etc. Directly hitting on the main demand of the question, what was the new objective and new orientation? You focused more on implementation or application rather than theory building. This was one of the major differences. Subnational and supranational studies started to be conducted, which was not previously the case. Previously, we focused on universal grand theories. We now started to focus on middle range theory building. right? Instead of a grand theory, it attempts to compare governments at all levels and at similar levels. Similar governments are compared at similar levels only, and that is how you call it middle range theory building. You also had study of multilateral institutions such as UN, World Bank, etc., rather than individualized nations. So this was the new objective orientation, that from moving from individual nations to multilateral institutions, moving from universal grand theory to middle range theory building, moving from cross national and cross cultural to subnational and supranational, focus more on implementation side rather than just theory building, right? Also try to mention about what were the new thrust areas. So these were the new orientations. What were the new objectives? We try to include human rights enforcement, disinvestment, international interdependency, citizen charter, role of people, debureaucratization, that is changing the nature of bureaucracy, and changing the nature of bureaucracy from regulatory to developmental, because this was needed in developing countries. This was needed in developed countries, right? You had a role of the private sector. You also had the role of the multilateral institutions, etc. Old CPA, new CPA. In terms of objective, you had a universal theory. Objective here was theory implementation. The approach here was empirical and ecological. Here you had methodological pluralism. There was a pluralism in terms of not only institutions but also methodologies to arrive at the comparative public administration studies. You had a Western bias in the old CPA studies. You had a less Western bias. It was ethnocentric. You had cross-cultural, cross-national, you had subnational, supranational levels. Critically examine. You also try to talk about the negatives of new CPA and some similarities as old CPA. The CPA in contemporary times has emerged as one such a formidable core area of public administration, which has also been affirmed by MBC3 in 2008. You know about how Manipur Conference talked about CPA studies, right? But the new CPA was not able to overcome the challenge of the old CPA and is still unable to form LNE universal theory. The main aim of CPA studies was to come out with a universal theory, either by grand universal theory or by middle range theories, right? So middle range theories were also developed so as to come out with a universal theory. But till date, we have not been able to achieve any universal theory. We also know that it is going through a polyparadigmatic phase. So you know that CPA went through a pre-paradigmatic phase, and then you have a polyparadigmatic phase. Polyparadigmatic phase basically means that there are many paradigms that are now running simultaneously as far as the CPA studies are concerned as on today. So there's a tough distinction to decide as to which paradigm belongs to which part of the CPA studies. So there's another problem in terms of polyparadigmatism of the CPA. There is lack of consensus on where it is heading, and the trajectory and perspectives are not clear. There is also adoption of universality as well as simultaneous rejection of universality, which is making the subject of CPA very, very vague and undefined. So this is how you can critically examine it. Conclusion, try to move on to the positive note that nevertheless, the new CPI has reduced ethnocentrism and made public administration more global and less Anglo-American, and there lies the significance of CPA. And we hope that it helps in furthering the research and the status of discipline to move towards being universal. Right? Did you all understand this? Any doubts?
Yes, sir.
All right, perfect.
Sir,
Hanji.
can we say polyparadigmatic because there were so many theories as subject matter to be studied?
मेरे को समझ में नहीं आया, एक बार वापस बोलेंगे?
Sir, we can say polyparadigmatic phase because of multiple subject matters.
Yes, obviously. The
Okay,
different paradigms came in because of the different subject matters, right?
okay, sir. Thank you.
All right. Moving on to the third question. Third question is nothing but a comparison or similar connotation of how Weber led to CPA or what. So Weber's construct of bureaucracy has served a great heuristic purpose in furthering research in the field of CPA. Do you agree? We'll say yes and no as well. And yes, will tell us what are the similarities of Weber, or how did we use the Weber's construct. So we all know that the first kind of study of CPA was through the Weberian models, wherein they act as benchmarks, right? For the features of Weberian bureaucracy act as benchmarks for us to study different national systems. However, we'll also say that we have moved from beyond Weber also, in the sense that we have also adopted the structural functional approach. We have also adopted the ecological approach, right? So there were majorly three approaches: Weberian approach, structural functional, and ecological. Weber will tell about acting as a benchmark. Then we'll, to disagree, we'll also talk about structural functional analysis of Talcott Parsons and the ecological approach adopted by Riggs. Okay. Introduction, body, explain brief about bureaucratic application, thesis statement, and conclusion. Introduction, CPA experienced different approaches in comparative studies. Max Weber bureaucratic approach is the oldest model. Body, Weber's model of bureaucracy is we'll try to include as many keywords of Weber in a single sentence because it's a 10 marker, right? So Weber's model of bureaucracy is characterized by a hierarchical structure, division of labor, specialization, impersonality, rules-based system, etc. Although there have been intermittent efforts to construct the model of administration, bureaucratic model of Max Weber was one of the dominant models that have come up for discussion among the students of CPA. Weber's construct of bureaucracy, this is the direct heading, has served as a great heuristic purpose in furthering research in the field of CPA. Why? We'll talk about the perspectives. So first and foremost is the concept of universality. Weber's construct of bureaucracy provides a universally applicable framework to study and compare public administrative systems and different systems or different settings, right? You know that Weber also called his own theory as universal, and we also know that CPA tried to achieve the universality. So this is the first common point. Second, ideal. So Weber's model, so all the features of Weber serve as a benchmark for countries looking to reform their public administrative system. Third, historical perspective. Weber's construct of bureaucracy offers a valuable historical perspective. You know that he has talked about Germany, right? And the studies are conducted in Germany, and it was for a Western developed industrialized nation in general. This is what a historical perspective is being offered by the Weberian studies or Weberian model, wherein the concept of bureaucracy offers a valuable perspective on the evolution. So you know that Weber's bureaucracy has failed in functions, in performing developmental functions. However, it was successful in performing regulatory functions. This was back then. So it is offering a historical perspective in the sense that when the need of the hour was regulation, then Weber's bureaucracy is perfect. However, in development, it will fail. And this will help us in becoming down to a point of comparison as well. Fourth is the interdisciplinary approach. You know that Weber was a sociologist. However, he came out with an administrative theory, and which can also be linked to political science. So Weber's theory was interdisciplinary in itself. That is why you can also see CPA to be interdisciplinary. Encouraged interdisciplinary approach. His ideas have influenced scholars from various disciplines like sociology, political science to contribute to the understanding of public administration. He also laid down a theoretical foundation for further research in the field of CPA. For example, you had a street level bureaucracy concept by the Michael Lipsky. He has also laid down certain theoretical foundational concepts. Also, please do not conclude. Try to tell them that it is not only Weber. He has laid the foundation. However, structural functional approach as well as the ecological approach has also helped in coming down to the present CPA studies, and we are furthering on these aspects. This was given by Talcott Parsons, right? On that note, you move towards the conclusion. Weber's construct of bureaucracy has served a great heuristic purpose in furthering the research in the field of CPA, ultimately leading to the advancement of knowledge and the development of more effective public administrative systems across the world, in the hope that we try to make the public administration theories universal in nature. And he has also helped us to study that grafting is better than transplantation. Two standard conclusions in any CPA question: universality and grafting. Yes.
Sir,
Hanji.
sir, where should we write about other two approaches? Structural, that
Yeah,
Talcott.
because the question is majorly on Weber, so you do this before conclusion. Just also write down that it is also not only Weberian model that was followed. As on today's structural functional approach as well as ecological approach helps in furthering the CPA analysis, which is the need of the hour because of the varying different socioeconomic contextual political settings. In just one line, and then you start concluding.
Okay, sir. Thank you,
This
sir.
one line is something that will be ignored by everybody, which might get you a 0.5 or a 1 mark extra. That is why I'm telling you to include it. Yes.
Okay, sir.
Yes, although this is a easy question if you break it down, but looks tough at the very outset. तो इसमें जितने भी कीवर्ड्स हैं ना उनको थोड़ा अच्छे से ब्रेक करना पड़ेगा. Just give me a second. Yeah. So the more exogenetic the process of diffraction, the more formalistic and heterogeneous its prismatic phase is, comma, the more endogenetic the process was, the less formalistic and heterogeneous will it be. Examine this hypothesis of Riggs. If you look at the keywords, you have exogenetic and endogenetic. ये पहला हो गया. तो you have exogenetic changes and endogenetic changes. The second is diffraction and prismatic phase. You have to explain this as well. Third is explaining the two terms such as formalism and heterogeneity. Okay, this is a 20 marker. Try to explain all of these differently. First, we talk about formalism and heterogeneity, talk about what the model encompasses in terms of prismatic phase and diffraction phase, talk about what are endogenous changes and exogenous changes, and at last, once you've done all of this, try to link it that कैसे जितना exogenous change होगा उतना ही formalism और heterogeneity आएगी, जितना कितना endogenous change होगा उतना कम formalism और heterogeneity आएगी. तो we all know that exogenous change is the change which from outside, तो वो negative connotation में है, इसलिए ज्यादा formalism है. Endogenetic change अंदर से है तो कम formalism और ज्यादा success है. And you try to link all of this and then conclude. ठीक है. It's a difficult question, but in such questions, try to look at the keywords. So exogenetic, endogenetic, diffraction, prismatic, formalism, heterogeneity. और कहीं कहीं पे आपको अगर ओवरलैपिंग तीसरा जो कीवर्ड होता है वो भी एक्सप्लेन करना है तो वो भी कर सकते हो. ठीक है. ठीक है. Introduction, brief introduction about Riggs, body, explaining the thesis statement. Try to include as many examples as you can, and then examine and conclude. Introduction, Riggs has been a seminal thinker in the field of CPA and the discipline of public administration who has provided his models for analyzing the administrative phenomena. Body, try to talk about the theory of prismatic society directly so that you have the keywords such as ये जो दो कीवर्ड्स है ना, एक तो फॉर्मलिज्म और हेट्रोजेनिटी आ ही जाएगा प्रिज्मेटिक सोसाइटी में, और दूसरा प्रिज्मेटिक और डिफ्रैक्शन भी आ जाएगा. So Riggs, on the basis of empirical research, came out with an improvised and specified model of development. This model is commonly known as the prismatic model. Riggs further elaborated his model of development into three ideal polar types: the fused, diffracted, and prismatic. All these models were distinguished by Riggs on the basis of his structural functional analysis. Some of the important characteristics of the prismatic society are heterogeneity, formalism, and overlapping. These are the major problems of prismatic society as per Riggs. What is heterogeneity and what is formalism? Simultaneous existence of different kinds of systems and viewpoints is heterogeneity. For example, you have rural as well as urban structures in India. You have ancient education systems as well as Western education systems. You have different medical connotations such as homeopathic as well as allopathic. So this is the example of coexistence or simultaneous existence. Formalism, I have already told you enough. What is the difference between ideal and reality? What is the difference between theory and practice? Similarly, excessive adherence to prescribed norms and rules and regulations are prescribed, but wide deviations are observed. This is called as formalism. These are the perfect features of a prismatic society, right? Try to talk about what are the exogenetic and the endogenetic processes. Riggs has talked about two types of changes in the context of his analysis of development. There are two types of changes. One is called the exogenous change, other called is endogenous. When there is endogenous change, society moves to diffraction. And when there is exogenous change, society moves towards prismatic. So we know that exogenous change is negative. तो आप least developed को developing की तरफ तो ले जा सकते हो. But अगर आपको developing को ही या least developed को exactly developed की तरफ ले जाना है, तो you need an endogenous change or a change from within, right? Now try to link it down to how it will bring in more formalism, etc., by giving down examples. So exogenetic process leading to more formalism and heterogeneity. Why? Because when the change or policies is influenced by external factors such as international agreements, etc., it becomes more heterogeneous and formal. For example, LPG, जो था, it did not have an impact in developed countries. Citizen charters is not so successful in India. You can also try to include the example of triple Ps in India. Similarly, Indian bureaucracy's organizational structure has been heavily influenced by the British colonial administration, resulting in higher formalism and heterogeneity. Here, you can directly use that keyword wherein we say that drafting is better than transplantation. And we know that transplantation would be exogenetic, however, drafting would be endogenetic. Right. So endogenetic processes lead to less formalism and heterogeneity. Why? Because changes from within are observed. That is from people, government, citizens, or civil society organizations themselves bring about change. For example, a perfect example would be Swachh Bharat Abhiyan, nudge behavior theory. है ना, आप behavior को ही change कर रहे हो from within. So it's an endogenetic change, and that is why it has been a very big success. It was primarily driven by the needs to address the issue of sanitation and cleanliness, thus leading to a more streamlined and homogeneous system of implementation. Also, a 73rd, 74th Constitutional Amendment Act implementation was also an endogenous change, wherein there was a political will to bring about the change, and that is why it is successful in India as on today. You have to examine, also tell us, अब हमने इतनी बुराई कर दी है exogenetic change की, but also tell them that exogenetic also is important. Otherwise, endogenetic would not be successful. However, it is essential to note that this hypothesis may not be universally applicable, and the relationship between endogenetic and exogenetic processes and their impact on formalism and heterogeneity may vary depending on the specific context and other factors. इसमें आप ये भी बता सकते हो कि how all developing countries are not having only the features of developing, some features of developed as well. Similarly, developed countries have some features of developing as well. So that is why you need both endogenetic as well as exogenetic changes. Though developing countries have exogeneric process of diffraction, prismatic or developing countries also have some features of diffracted society, such as balanced polity. At the same time, not all the developed have all the features of diffracted society. They may also have some features of prismatic society. That is why both changes are needed, right? In conclusion, in broad sense, it is considered that society should have endogenous change to have long-lasting impact, long-lasting and sustainable, impactful change. Yes. Did you all understand this question?
Yes, sir.
Perfect. Moving on to the last two questions. These are very, very common and very direct. The approach to the study of administration in its environmental context is especially more useful for developing countries. You're basically saying that CPA is useful for developing countries. How and why? Because we know that all the theories before CPA were made for developed countries, Western industrialized nations, developed nations were focused upon. So we needed a focus on developing countries, wherein a lot of scholars came around different developing countries and came up with theories on how their administrative systems were different. That is why we needed CPA studies. Yeah, it's a 10 marker, pretty small. Introduction. Several scholars such as Goss, Dahl, Martin, Riggs have emphasized the importance of study in the ecology of administration. Body. The study of administration in its environmental context is more useful for developing countries because it helps in understanding the socio-political, economic, and cultural factors that influence the functioning and effectiveness of administrative systems in these nations. For example, poverty alleviation programs such as Maganrega, affirmative actions to uplift socioeconomic disadvantaged sections. These are all things that we will see in developing countries only, right? So that is why studies in the context of their environment becomes important in such countries. The classical this here you're establishing as to that previous studies have already talked about the developed countries. So we need developing countries to be focused upon. The classical behavioral approach followed by a universal model of administration equally applicable to all the societies. It was to study the developing countries that the CPA was developed, as the traditional Weberian model was found to be inadequate to analyze these societies. It was good for regulatory functions, but not for developmental functions. This is for developed countries, the models for which have already been developed. For developing countries, you needed developmental functions where the traditional form of bureaucracy failed. Therefore, Riggs came out with the ecological model to study the prismatic society. Public administration is evolved in USA as per its own ecology. Hence, there is no need to study the ecology of public administration because it has been ethnocentric and Western dominated. For instance, the Industrial Revolution, rationality, bureaucracy linkage, the PubAd in these countries are a product of the ecology of the West. That is why we needed new administrative studies for the developing countries, which was done through the CPA studies, right? But we came to know that the administrative realities of the developing nations only after the ecological studies. For example, Riggs in Thailand, Brebanti in Pakistan, and Evans in Pakistan, and Palambora in Russia, right? Thus, they realized differences between developed and developing nations. Most developing countries failed in development administration because they have transplanted the structures instead of grafting them without taking into consideration the environment, right? Example, Weberian bureaucracy was introduced, keeping in focus conditions of Western society, but developing countries tried to imitate it and could not get the result. Results give examples, Citizen Charter and Triple P. However, policies and decisions that are taken while keeping in consideration the environmental context comparatively perform well. So, for example, you have the success of SHGs in Bangladesh and copied in India. Both of them have similar environmental context. That is why they have been a success. Similarly, cooperatives such as Amul, policy decisions such as Swachh Bharat Abhiyan, all of these were grafting, right? That is why they have been successes. Conclusion. Thus, we can say that the ecology of administration is overwhelmingly applied to understand the administrative systems of developing nations vis-a-vis its technology so that there can be better policy cycle and governance. Did you understand this? I kept it a little fast because examples are also similar. We have this is something which is very basic. Whenever you study about CP, you know that it is being done for developing countries only, right? Yes.
Sir,
Anji.
sir, please tell this question again in brief.
ठीक है तो आपको इसमें क्या नहीं समझना है पहले ये बताओ मतलब आपको क्वेश्चन समझ में आया
सर ज्यादा फास्ट हो गया सर, हाँ क्वेश्चन समझ आ गया।
ठीक है, तो इसमें बेसिकली हमने ये बोला है कि जो सीपीए स्टडीज हैं वो डेवलपिंग कंट्रीज में क्यों इंपॉर्टेंट है। ठीक है, उसके दो पार्ट्स हैं। पहला पार्ट ये है कि डेवलप्ड कंट्रीज में तो बहुत सारी स्टडीज ऑलरेडी हो चुकी है, तो जितने भी थिंकर्स हैं उसके लिए ये पैराग्राफ है कि जो क्लासिकल और बिहेवियरल अप्रोच है, जितने भी पहले वाले थिंकर्स हैं वो डेवलप्ड कंट्रीज में स्टडी कर चुके हैं। तो
यस
पहली
सर।
बात तो ये होगा कि डेवलप्ड कंट्रीज के लिए ऑलरेडी स्टडी है, तो डेवलपिंग के लिए चाहिए। सेकेंड बात हम ये स्टैब्लिश कर रहे हैं कि जो डेवलपिंग कंट्रीज हैं उनमें डिफरेंट डिफरेंट कंडीशंस हैं, तो देयर आर डिफरेंट सोशियो पॉलिटिकल कंडीशंस, देयर आर डिफरेंट इकोनॉमिक कंडीशंस, देयर आर डिफरेंट कल्चरल फैक्टर्स। एंड जब ये सारे थिंकर्स जो थे ना सीपीए के, जैसे रिग्स थाईलैंड में गए, ब्रह्मांडी पाकिस्तान में गए, पैलम्बोर रशिया में गए, तो जब तक ये नहीं गए थे हमको डेवलपिंग कंट्रीज की नई नई प्रॉब्लम्स ही नहीं पता थी। तो दैट इज वाई सीपीए बिकेम इंपॉर्टेंट डेवलपिंग कंट्रीज टू रियलाइज देयर प्रॉब्लम्स। थर्ड, हम बोलते हैं कि जैसे वेबेरियन वेबेरियन ब्यूरोक्रेसी थी, वो वेस्टर्न इंडस्ट्रियलाइज डेवलप नेशन के लिए बनी थी क्योंकि वो जर्मनी के लिए बनी थी, तो इट वाज सपोज टू परफॉर्म रेगुलेटरी फंक्शंस। बट आज के डेट में डेवलपिंग कंट्रीज में वी नीड टू मूव फ्रॉम रेगुलेटरी फंक्शंस टू डेवलपमेंटल फंक्शंस, राइट। तो उसमें वो फेल कर जाती है, इसलिए हमको नई सीपीए स्टडीज चाहिए। उसके अलावा हम थोड़े बहुत नए एग्जांपल्स दिए कि हाउ कॉन्टेक्चुअली जो चीज डेवलप होती है वो सक्सेस होती है, वर्सेस जो कॉपी होती है, जैसे डेवलप्ड से हमने सिटीजन चार्टर और ट्रिपल पी कॉपी किया, वो इंडिया में फेल इसलिए हुआ कि हमने डायरेक्टली कट कॉपी करा। हाउएवर अगर हम इंडिया के कॉन्टेक्स्ट में कुछ डेवलप करते हैं, जैसे एसएचजीस था, बांग्लादेश में डेवलप हुआ, सिमिलर कॉन्टेक्स्ट टू इंडिया, तो वो आज की डेट में सक्सेस है। कोऑपरेटिव्स लाइक अमूल आर सक्सेस, पॉलिसीज जैसे स्वच्छ भारत अभियान आर सक्सेस बिकॉज दे हैव बीन अप्लाइड इन द इंडियन कॉन्टेक्स्ट। समझ आया?
यस सर।
ठीक है,
थैंक यू सर।
थैंक यू। लास्ट क्वेश्चन फॉर टुडे। In the modern context, Rixian terms have not altogether disappeared, but have emerged in different forms with newer meanings. Basically, बोल रहे हैं, जो आप रिक्स के टर्म्स पढ़ते हो, और दिस इज अ वेरी सब्जेक्टिव क्वेश्चन, आई हैव ट्राइड टू इंक्लूड इट इन द सब्जेक्टिविटीज दैट आई एम लिमिटेड टू। आप अपनी सब्जेक्टिविटी में कुछ भी इंक्लूड कर सकते हो, बस वो रेलिवेंट होना चाहिए। वो बेसिकली बोल रहा है कि जो सब्जेक्ट जो भी रिक्सियन टर्म्स हैं, जितने भी कीवर्ड्स हैं, उनका पहले ये मीनिंग था, आज की डेट में ये मीनिंग है बस। तो वो इसलिए स्टिल रेलिवेंट है। उसी कीवर्ड्स को अलग अलग तरीके से हमको एक्सप्लेन करते जाना है, वो आप अपनी मर्जी से भी कर सकते हो। आई हैव ट्राई टू ब्रिंग आउट opinion of my own which might vary, and I'm also not happy with that opinion myself, but this is what I could have come up with only। ठीक है, रिग्स का इंट्रोडक्शन विच इज वेरी स्टैंडर्ड इन द बॉडी। रिग्स प्रिज्मेटिक मॉडल जो हमने पहले डिस्कस किया था ना, वही है। रिक्स प्रिज्मेटिक मॉडल वाज डिजाइंड टू एक्सप्लेन द प्रोसेस ऑफ स्पेशलाइजेशन। व्हेन अ सोसाइटी ट्रांजिशंस फ्रॉम फ्यूज्ड टू डिफ्रैक्टेड, द लेवल ऑफ स्पेशलाइजेशन राइजेस। Prismatic society is somewhere in the middle. It focuses on developing countries that he describes as prismatic with the following features as heterogeneity, formalism and overlapping। आप ये तीन फीचर्स एक्सप्लेन करो, उसके बाद जितने भी कीवर्ड्स हैं हम वो डिस्कस करेंगे। एक्सक्यूज मी। Heterogeneity, it means society is divided into haves and have-nots. The bureaucracy would protect the interests of haves more, ignore the have-nots, जिसकी वजह से revolution होगा। Formalism is difference between the stated and practiced is high. Thus, bureaucracy plays a dominant role in policy making. You all know these three keywords. We've discussed them a lot of times. Overlapping when new structures are still dominant by the old systems. Thus, parliament markets are present but still dominated by structures such as family or notions such as family, caste and tradition। ठीक है, छोटे से अपने रिक्स को एक्सप्लेन किया। Now you'll directly hit upon the keywords. So for example, you have the keywords such as prismatic society, the keywords such as Pasala model, ऐसी बाजार कैंटीन मॉडल एक कीवर्ड है, फ्यूज एंड डिफ्रैक्टेड सोसाइटीज एक कीवर्ड है। ठीक है, अब इन कीवर्ड्स का आप पहले बताओगे कि जब वो स्टार्ट हुए थे क्या मतलब था और आज की डेट में क्या मतलब है। ठीक है, ये बहुत सब्जेक्टिव पार्ट है, तो आप कुछ भी सोच सकते हो इसमें, बट कॉमन क्या रहेगा उसका पहले वाला मीनिंग। पहले वाला मीनिंग तो हम सबको पता है, न्यू मीनिंग सब्जेक्टिवली वेरी करेगा। So Riggs originally described prismatic societies as those that exhibit a mix of traditional and modern characteristics, often leading to administrative inefficiencies and complexities। ठीक है, ये ओरिजिनल मीनिंग है। अब मॉडर्न कंटेक्स्ट में क्या मीनिंग है? दिस कॉन्सेप्ट हैज बीन एक्सपैंडेड टू इंक्लूड सोसाइटीज दैट आर अंडरगोइंग रैपिड सोशल, इकोनॉमिक एंड पॉलिटिकल ट्रांसफॉर्मेशंस, नॉट जस्ट दोज इमर्जिंग फ्रॉम कॉलोनियलिज्म। तो पहले हमने देखा था कि डेवलपिंग नेशंस वो होते थे जो यूजुअली कॉलोनाइज थे और अब फ्री हो गए हैं, है ना। उस टाइम पे 1950s के टाइम पे यही हो रहा था, बट आज की डेट में जो सोसाइटीज अभी सोशल इकोनॉमिक एंड पॉलिटिकल ट्रांसफॉर्मेशन के थ्रू भी गो थ्रू कर रही है, वो भी प्रिज्मेटिक हम कह सकते हैं। तो कॉन्सेप्ट सेम है, बट वो हम एक्स्ट्रापोलेटली अप्लाई कर रहे हैं। सो द कॉन्सेप्ट कैन बी अप्लाइड टू अंडरस्टैंड द चैलेंजेस फेस्ड बाय कंट्रीज लाइक इंडिया, वेयर एस्पेक्ट्स ऑफ ट्रेडिशनल एंड मॉडर्न सोसाइटीज को एग्जिस्ट एंड पब्लिक एडमिनिस्ट्रेशन नीड्स टू अडैप्ट अकॉर्डिंगली। सेकेंड, साला मॉडल, ये ब्यूरोक्रेसी की बात करता था। तो साला मॉडल वाज proposed by Riggs as a representation of the bureaucratic structure in prismatic societies। इनके क्या क्या फीचर्स थे? फॉर्मलिज्म थी, रिजिडिटी थी, और लैक ऑफ स्पेशलाइजेशन थी। आज की डेट में क्या बोल सकते हो कि ये जो टर्म है, इट इज इवॉल्व टू रिप्रेजेंट द चैलेंजेस फेस बाय पब्लिक एडमिनिस्ट्रेटिव सिस्टम्स इन डेवलपिंग कंट्रीज एज ऑन टुडे। जहाँ पे फॉर्मलिज्म, रिजिडिटी और लैक ऑफ स्पेशलाइजेशन के अलावा आज क्या क्या है? ब्यूरोक्रेटिक इनफिशियंसीज है, रेटिपिज्म है, करप्शन है, नेपोटिज्म है, फेवरेटिज्म है, ठीक है, abuse of power है, misuse of authority है, ये सब है। The Sala model can be used as a framework to analyze the need for administrative reforms. You can also link it to the need for administrative reforms and the introduction of new governance models in these countries. Yes, ये समझ में आ रहा है ना?
Yes, sir.
Yes. Third, fused and diffracted societies. Originally क्या होता था? Originally, these terms are used to describe the two ends of a spectrum, developed and underdeveloped, है ना? With fused societies representing traditional societies and diffracted societies representing modern industrialized societies. However, आज की डेट में क्या बोल सकते हो? These terms have taken on newer meanings, with fused societies referring to those where the state has limited capacity to govern, and diffracted societies representing those with strong, well-functioning institutions. ठीक है, दिस यू हैव टू, दिस इज जस्ट अ वर्ड प्ले कि आज की डेट में वो उसका क्या मीनिंग है। This new understanding allows for a more nuanced analysis of the different stages of development and governance capacity in countries around the world। हम बेसिकली यही मॉडल फॉलो करें कि पहले क्या बोलता था, अब क्या मीनिंग है, और तीसरा ये क्यों यूजफुल है ना? ऊपर भी हमने यही किया था। तो ये इसलिए यूजफुल है कि इससे नया एनालिसिस मिलेगा हमें डिफरेंट स्टेजेस ऑफ डेवलपमेंट का और गवर्नेंस कैपेसिटीज का। और आज की डेट में गवर्नेंस कैपेसिटी जिसकी पुअर है वो फ्यूज्ड है, गवर्नेंस कैपेसिटी जिसकी अच्छी है वो डिफ्रैक्टेड है। पुराने टाइम में क्या था, जिसकी ट्रेडिशनल सोसाइटी थी वो फ्यूज था, और जिसकी डेवलप्ड सोसाइटी थी वो डिफ्रैक्टेड था। Fourth, bazaar canteen model. Riggs introduced this model to explain the coexistence of traditional एंड मॉडर्न इकोनॉमिक सिस्टम्स, है ना? तो ट्रेडिशनल सिस्टम को बाजार कहते थे, मॉडर्न को कैंटीन कहते थे, वो प्रिज्मेटिक सोसाइटीज में था। हाउएवर आज की डेट में हम क्या कह सकते हैं? दिस मॉडल कैन बी यूज्ड टू एनालाइज द चैलेंजेस फेस्ड बाय पब्लिक एडमिनिस्ट्रेशन सिस्टम्स इन मैनेजिंग द कॉम्प्लेक्स इंटरप्ले बिटवीन ट्रेडिशनल एंड मॉडर्न इंस्टीट्यूशंस, एज वेल एज द नीड टू बैलेंस द डिमांड ऑफ डिफरेंट स्टेक होल्डर्स। अलग अलग टाइप के स्टेक होल्डर्स हैं, उनकी डिमांड्स को कैसे बैलेंस करता है हमारा इकोनॉमिक सिस्टम, और ट्रेडिशनल और मॉडर्न इंस्टीट्यूशंस के बीच में कैसे इंटरप्ले करता है। पहले क्या होता था? ट्रेडिशनल और मॉडर्न इकोनॉमिक सिस्टम्स को कवर करता था वो, कि बाजार क्या होती है और कैंटीन क्या होती है। ये जो हमने स्टैंडर्ड पढ़ा हुआ है वही है, और हम आज की डेट में उसको एक्सट्रापोलेट कर रहे हैं। इसके अलावा यू कैन ट्राई टू इंक्लूड डाउन वेरियस एग्जांपल्स सच एज डेविएशन फ्रॉम रूल ऑफ लॉ व्हिच इज कॉल्ड एज फॉर्मलिज्म, डिस्क्रिमिनेशन, polycommunalism, polynormativism, interference in government and bureaucracy. Try to include as many keywords as you can as per the space that you have given. Conclusion: to include Rixian terms have not disappeared in the modern context but have evolved to incorporate newer meanings and complexities. These terms continue to be relevant in understanding the challenges faced by public administration systems in developing countries and provide useful frameworks for analyzing the need for administrative reforms and the introduction of new governance models. ये समझ में आ गया या कोई डाउट है?
आ गया सर।
Done. If you have any doubt, let me know. Otherwise, we are done for the class for today. Took it a bit longer. Took it a bit long because we had 3 units, but I hope that you found it of some utility. Right? Yes. Any doubts? Otherwise, we'll end the class for today. All right, then. Thank you. I'll immediately drop the 3 synopsis PDFs on the group. You can also
Thank
reach
you,
out.
sir.
Thank you. Bye bye.
Okay, sir. Thank you, sir.
Thank you.